citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates the capacity to establish unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration laws, but also jump in front of those who follow the rules. It has spawned a sprawling industry of birth tourism as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions.
General Sauer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship. It was a diversity case. And of course, we know what Chief Justice Taney did with that.
Hey, good morning.
How
Good morning, good morning, good morning.
The Citizenship Clause responds specifically to Dred Scott and answers or changes or corrects
Birthright.
his answer as to citizenship.
Citizenship.
The other point is the Citizenship Clause refers not just to national citizenship, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States and citizens of the state wherein they reside. So as you begin, I'd like you to go back at the beginning and be more specific about the answer. And I want you to explain whether or not those two definitions are the same or related, and what state citizenship is based on.
Thank you, Justice Thomas. I'll maybe start by addressing Dred Scott. As you alluded to the fact, Dred Scott, imposed one of the worst injustices in the history of this court, and it led to the outbreak of the Civil War. It's very clear, and this court in all of its early cases interpreting the 14th Amendment said, the one pervading purpose, the main object of the Citizenship Clause is to overrule Dred Scott and establish the citizenship of the freed slaves. And if you look at the debates in the congressional record and discussion surrounding the adoption of the Citizenship Clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship of domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or sort of being subject, merely subject to the laws. They're talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause, we believe it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and the states in which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that word reside, if you look at, for example, section 1473 of Justice Story's commentaries, was understood to mean domicile. So when they say subject to the jurisdiction, and then they go on to say you're a citizen of the United States and the state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States. If they're present in a state at all, they reside there. Reside means domicile in the Constitution. And we think that strongly supports our interpretation. It's textual evidence of our domicile-based theory of jurisdiction.
Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction thereof. But the examples you give to support that strike me as very quirky. Children of ambassadors, children of enemies during a hostile invasion, children on warships. And then you expand it to the whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples?
There are those sort of narrow exceptions for ambassador foreign public ships. Tribal lineage is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power. Now, if you go back to Blackstone and Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to the king at any time. So there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power, and then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. That is what it means. And this court picked up on that in Elk against Wilkins when it says it uses, completely subject to the political jurisdiction, not merit regulatory jurisdiction.
What do you do with Juan Kim Ark's quote of Daniel Webster, who said, independently of a residence, with intention to continue such residence, independently of any domiciliation, independently of the taking of any oath of allegiance, or of renouncing any form of allegiance. It is well known that by the public law, a non-citizen, while he is here in the United States, owes obedience to this country's laws. Now, the examples that Wong R. Kim used as exceptions are situations in which there was not temporary allegiance to the United States. The children of foreign diplomats whose only allegiance was to their foreign country, and or occupied territory residents, including those citizens in Maine who had been occupied by the British forces. The U.S. had no control over them. And the whole theory of the Indian tribes was similar. The Indian tribes were analogized to foreign diplomats. So what do we do with that?
I'd say two things. First, as the Indian tribes, we think that's a case that strongly supports us because, of course, by 1866 and 1868, there was strong understanding that the Indian tribes were subject to the United States' regulatory jurisdiction.
But not the same way that temporary foreigners were. Meaning there was a real debate going on whether the U.S. actually had jurisdiction over Indian tribes. That's why our cases, the longest time, until that was finally settled, said, absent some act of Congress, our laws don't apply. U.S. laws don't apply to Indians on Indian lands, correct?
I believe you look at the Rogers decision, for example, that we cite in our brief, where they say that they are subject to the...
That's later. I'm talking at the time.
Yes, at the time. So as to 1817...
So what do you do during the debates of the 1866 Civil Rights Act and of the 14th Amendment? With the entire discussion of the people who opposed the amendment, who kept saying, we can't pass it because we're making citizens of gypsies who have no allegiance to anybody, and we're going to make citizens of Chinese people who can't be citizens because we're not going to permit them to be citizens. What do we do with those debates and the fact that the proponents of both acts said everyone who's born in the U.S. will be citizens?
First,
Hey, good morning. Come on in.
Exchange, page 2890 of the congressional record from 1866. Senator Cowan gives this virulently racist statement where he says that. What does he say right at the beginning of that sort of offensive speech? He says we can't have children of gypsies, children of Chinese immigrants. We can't have them become citizens. And he says, quote, have they any more rights than a sojourner in the United States? So he's trying to persuade the Republicans to his view by appealing to a common understanding that sojourners do not have children who become citizens. So there's powerful evidence there that everybody understood this to, not sweep in the temporary sojourner. And that's why you see for 40, 50 years, you see every commentator who addresses the specific question of temporary presence saying it's not covered by the clause, including for decades after Wong Kim Ark.
General, can I take you back to the Chief Justice's question about the specific exceptions to birthright citizenship that everybody seems to agree were recognized under the common law. And it brings up an important principle about how we interpret the law. When particular problems pop up, lawmakers may enact a general rule. When they do that, is the application of that general rule limited only to the situations that they had in mind when they adopted the general rule, or do we say they adopted a general rule, they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven, and then afterwards someone is charged with the crime of stealing a microwave oven, and this fellow says, well, I can't be convicted under this because the microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time when the 14th Amendment was adopted, which is illegal immigration. So how do we deal with that situation when we have a general rule?
Yeah, I strongly agree with the way that you framed it, that there is a general principle, that's a broad principle that's adopted in the phrase subject to the jurisdiction thereof, and we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations, and as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist, and it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from 1881 until 1922 are uniformly saying the children of temporary visitors are not included. Now that logic, we say, naturally extends. It's really an a fortiori case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you've entered illegally, it's kind of, a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You don't have the legal capacity to create domicile.
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country,
Hey,
where there was
Crystal.
quite clearly an experience of, an understanding of, that there were going to be temporary inhabitants. And your whole theory of the case is built on that group. You don't get to talking about undocumented persons until quite later and at much lesser, I think it's like 10 pages to 3 pages or something like that. So you can't really be going with Justice Alito's theory. You must be saying that there's a principle that developed, that was there at the time of the 14th Amendment. Isn't that right?
We agree there's a principle there at the 14th Amendment. It is jurisdiction means allegiance, the allegiance of in this very strongly reflected in the 19th century sources, the allegiance of an alien present in another country is determined by domicile. And that goes back to the Venus and the Pizarro. It goes through the Katza Affair in 1853. It comes right up to Fong Yui Ting and Lau Ao Bu that are decided shortly before Wong Kim Ark. So that's the principle. That principle clearly applies here. I also respectfully disagree.
Yeah, and I guess, Mr. General Sauer, where does this principle come from? Allegiance, domicile. Allegiance, I think you point to a Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of when we think of the word jurisdiction, and I appreciate that jurisdiction has many meanings, but the first meaning is like, if you're subject to jurisdiction, you're subject to the authority of. One doesn't say, what that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical, esoteric meaning. And then the question comes, okay, if the text doesn't support you, if there's a real history of people using it that way, but as far as I can tell, at the time of the 14th, you're using some pretty obscure sources to get to this concept.
let's take it straight from the framers' mouths. So, for example, Senator Trumbull was asked, what does jurisdiction mean? He means subject to the jurisdiction. He said, what does that mean? He says it means not owing allegiance to anybody else. He is the principal framer of the Civil Rights Act of 1866. Representative Bigham, who's the framer of the 14th Amendment, is asked, what does it mean in the congressional record at page 1291? He says, within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. And we've cited many, many examples where the congressional debates reflect that. Then you referred to the oration of George Bancroft. That's one of probably 16 sources, but there's at least 13, counting that one in the 12 treatises we cited, pages 26 to 28 of our brief. There is over a dozen sources that specifically address temporary sojourners in the 5 decades after the enactment of the amendment. Every single one of them says, well, temporary sojourners, their children are not included, including for 2 decades after Wong Kim Ark. So,
if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868, or do we look at it how it's understood today in context of the INA?
The 1868, understanding not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1868. We really didn't have laws like that.
Good morning, Beverly.
So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
But that's 1898. Now I'm looking at 1868. You're telling me is what I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well, and decisions of this court.
So it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is applied to...
continually restrict who may lawfully be present more and more, and you would say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile. And so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the child, obviously. It's the parents you'd have us focus on. And, you know, what if, is it the husband, is it the wife? What if they're unmarried? Whose domicile?
Well, in the executive order, it draws a distinction between the mother and the father. It's really the mother's domicile. I think that would matter.
Well, but 1868 matters, you're telling us. So what's the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868? And do we have to do this for every single person?
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept that's been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. Child's citizenship, and the focus of the clause is on the child, not on the parents. And you don't see domicile mentioned in the debates. The absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form.
Please hit the like button for me, please.
on the domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. And I point out that their position, like ours, is forced to look at the domicile of the parents. As you look at the exceptions that they
Wolf.
accept, like
I'm talking about
tribal Indians and so
I'm
forth.
talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many.
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few
Tamara.
examples. Page 1679 of the Congressional Record, President Johnson
He is
vetoes the
absolutely
first version
wrong.
of the Civil Rights Act, and he says, I can't sign this because it would extend alien citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources that you cited that say, well, again, this is a deeply rooted 19th century understanding. It's reflected in the Venus, it's reflected in the Pizarro in 1814 and 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Acts. Domicile is the key concept that creates allegiance. That's
General,
So
can
you
I?
said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And you can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. Right? And so it would be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, these people were not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there, by
Well, their
law,
intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, which says, well, lawfulness for a different purpose, but they're here, they're resident, let's take your assumption that they're not here unlawfully. Let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I think this is the flip side of the hypothetical that we were talking about earlier. Under 19th century law, they are treated as domiciled in the United States, so it would be astonishing. And the debates in the congressional floor talk about not this specific case, but they say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. I mean, they don't use the phrase domiciled like they use allegiance. They say they don't have allegiance, that once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're...
General,
How would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful. In other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
General, can I ask you a question? To follow up on what Justice Gorsuch was exploring with you with respect to domicile, did I understand you to say that domicile is going to be eventually or is controlled by Congress? Who is domiciled? I'm struggling to figure out who is domiciled in your argument.
The domiciliaries are people who are lawfully present and have an intent to remain permanently. So that's a kind of black letter, understanding of domicile. Now, Congress can't dictate that certain classes of people, legal entrants and so forth, cannot lawfully and lack the legal capacity to form a legally binding domicile.
If that's so, then doesn't it make the domicile for the purpose of the 14th Amendment turn then ultimately on Congress's will in a way that the framers did not intend. I mean, my understanding was the framers put this citizenship clause into the Constitution to prevent future Congresses from being able to affect citizenship in this way.
Sure. Very briefly, no, I don't think so, because it is up to the alien whether or not they want to be domiciled here. Now, there may be
But I thought you just said Congress can make determinations as to who counts as being domiciled here.
Yeah,
so if that's true, then it ultimately would impact, in your theory, whether or not this person can claim that they have citizenship for 14th Amendment purposes based on Congress's determination. And I just thought that's what the 14th Amendment was trying to get away from.
Yes.
Very briefly, I just point you to the discussion in Professor Warman's amicus brief where he talks about this is not a new problem. Going back even to the British common law, there's a situation of people who lack a safe conduct and are passing through the king's domains without permission. And he says the best reading of the common law is they are not under the protection of the king and they're not covered by the rule of birthright citizenship.
Thank you, counsel. You mentioned in your briefing and also this morning the problem of birth tourism. Do you have any information about how common that is or how significant a problem it is?
Wow.
It's a great question. No one knows for sure. There's a March 9th.
Chad Smith, what makes it right?
Letter
That means
from
that he will be
members of Congress
deported.
to DHS saying, do we have any
You
information
do
about
understand
this?
that while you're agreeing with him.
media
That means
reports
he has
indicate
to go,
estimates could be
plus
over
his
1
family,
million
all
or
of them,
1.5 million from the
except
People's Republic of China
Marla
alone.
Maples.
The congressional report that we
So
cited in our brief talks
don't make
about
statements
certain
without
hotspots
fully
like
understanding
Russian
what
elites
you're
coming to
saying.
Miami through these tourism companies. And
That means he has to
here's the
go.
facts about it that I think is striking. Media reported
What's
as
her
early as
name?
2015
Melania.
that based on
All
Chinese
her
media
kids.
reports, there are 500
Eric's
500
kids.
birth tourism companies in
All
the
of
People's
them.
Republic of China.
They should be deported
Business is
first.
to bring people here to give birth and return to that nation.
Having said all that, you do agree that
Yeah,
that has
okay.
no impact on the legal
Bye.
analysis before us?
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where their interpretation has these implications that could
It's
not
too early to
possibly
play
have
with
been
slow people,
approved by
dumb people.
the 19th century framers of this amendment. I think that shows that they've made a mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out to you, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world.
Where
It's
your
the
mama
same
from?
Constitution.
Where your daddy from?
It is, and
Where they
as
people
Justice
from?
Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our brief.
Thank you. Justice Thomas, anything further?
Generally, you're getting a lot of questions about immigration, and they harken back, of course, to
They're not.
citizenship, which
She was not born here. What do you mean? Melania was not born here.
Around the 14th Amendment had anything to do with immigration.
Trump was not born
I
here.
think that the principle.
So what the hell are you talking about, Barron? If his parents were not born here, what does that mean?
It has to do really not with immigrants, but with the Indian tribes. I mean, obviously, the main goal, the one pervading purpose of this court.
Chaz, do your Smith, do your research. You have no idea what you're talking about.
But they were very concerned about the problem of
birthright citizenship. Melania was not born here. Trump was not born here.
We draw an analogy to that, to the issue of temporary sojourners. And then, but there are mentions of temporary
So they should be the first to go.
in the congressional debates, and all of those quotes go in our direction.
And there was
No, she did not. Legally. What is the Einstein
there was no question in that case that
citizenship? No.
about domicile.
She was a part of the elite
I disagree.
what was it?
Says at the very beginning of the
Trafficking.
opinion, the accepted facts, these are
Trade.
lawfully domiciled here. When it states the question,
They gave her that. She did not go through the proper chain of command. Do your research, Chad Smith.
opinion says, here's the single question we've decided. We've decided that
She
Chinese
came over
immigrants
just like
with
those
a
other
permanent domiciled
traffic
residence here fall
minors
within the rule of
as a
birthright
model.
citizenship.
She was ran through the system. She was great.
Under the minimum
She was a part of the
definition
trafficking.
domicile,
Do your
which I think
research. You're at the wrong place.
existed in 1868 and
So
continues
shut up.
to exist today, a person's domicile is the place where he or she intends to make.
She did not obtain it properly.
Now, normally, you would think that a person who is subject to arrest at any time and removal could not establish a domicile.
Hey, Pat.
But we have an unusual situation
Good morning.
here because our immigration laws have been ineffectively and in some instances unenthusiastically enforced by federal officials. So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I may, one legal and one humanitarian. The legal point is, if you look at those cases, for example, Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule, and the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright
You're in
citizenship,
denial,
I don't think is
stupid.
a strong argument. And I point out,
Where your
honestly,
mama from? She
you know,
probably
for
illegal too.
reliance-related reasons, this executive order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree
Absolutely. Too
with
late
you. European
for a date.
nation's rule is.
Oh,
England was
stupid.
always subject to, isn't it?
Guy up there don't know what he's talking about. He's just a troll running his
That's not
mouth,
quite true. The
thinking he's
people
smart.
run, Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different.
Good morning, Rock
English
James.
rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do. You are asking us to overrule Wong Kim Ark? Well, Wong Kim Ark's parents were domiciled in the U.S., but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States. So you're not asking that. Are you asking us to overrule then our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you to overrule Wong Kim Ark. We agree with the holding of Wong Kim Ark and much of the reasoning. And then as for those later cases starting in 1966, where the court makes sort of unreasoned references to this
Wait a
issue,
minute, in top you loose, the respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, the child is of course an American citizen. That person wasn't domiciled here lawfully. So you're asking us to overrule that?
I wouldn't call
Moose Knuckles, yes, he did.
by jurisdictional ruling.
Cook
It's a simple
boys.
statement that's not
Absolutely.
debated. There's no further analysis of it. There's really an assumption there, and we think that's similar to cases where the court just assumes jurisdiction without discussing.
When we ruled in Trin that Indians could not become citizens, the government then asked
What's AI,
them to
Pat?
unnaturalize many Indians who had been sworn in as citizens. You asked us to concentrate only on the prospective nature of the citizens' order. But the logic of your position, if accepted, is that this president, or the next president, or a Congress, or someone else could decide that it shouldn't be prospective. There would be nothing limiting that, according to your theory.
If, as we asked, the court confines its ruling to prospective relief only, which it did in
No, I'm
session.
saying to you, that's what you're asking us for relief right now. I'm asking whether the logic of your theory would permit what happened after the court's decision in Trent, that the government could move to unnaturalize people who were born here of illegal residents.
No, we believe that the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate course here.
But that's not what we did in Trent.
We think that the Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief. Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of our history. And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, there's a very clear rationale. You say, oh, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States, and then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear rationale that is diametrically different from your rationale. And everybody took Wong Kim Ark to say that, and to say that as a result of that, of course, birthright citizenship was the rule, and I think everybody has believed that for a long, long time. And I guess my question is this. You have a story about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take, what do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized in their amici's briefs, which is in 1921, Richard Flournoy, who becomes a senior State Department official in the Roosevelt administration and pushes their theory as the temporary sojourners, writes a law review article in 1921 where he says, I think the children of temporary visitors should be citizens. But he admits that is not the understanding of Wong Kim Ark. He admits Wong Kim Ark did not hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including from decades after Wong Kim Ark, that say children of temporary sojourners are not included. What happens between 1921 and the 1930s? Well, Mr. Flournoy became a senior State Department official, and he adopted that as the policy of the Roosevelt administration. So their argument is basically saying there wasn't this consensus going back to 1898. The consensus, as their own author admits, goes entirely in the opposite direction. For 50 years, right, for 50 years from the framing of the clause through the 1920s, maybe 60 years, the general understanding when it comes to what's an issue here and what's not an issue in Wong Kim Ark is the children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to the sort of concept of temporary local allegiance, and they rely on the exchange, this theory that you've got temporary local allegiance. But if you actually look at page 572 of the congressional record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and owing allegiance to the United States, but I was aware that there's a, quote, a sort of allegiance for persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted the language and meaning that they say should be packed into these provisions is that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter, who dissented in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Like, suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born in the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but what do you do with that?
I'd say two things in response to that. First of all, he gave a speech. We have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme like you can't be doing this because you can't make and we all agree, or it's obvious, that the children of temporary visitors do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. And again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we've decided is the citizenship says the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what it is said, but your test is the domicile of the parents, and that would be the test you'd have us apply today, right?
Yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so, on our test. If they're lawfully domiciled here.
And then...
Not sure, I have to think that through, but that's my reaction.
I'll take the yes, that's all right. And then I just want to ask you quickly about the INA, adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines, that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation. I give 2 reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase, subject to the jurisdiction thereof, were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute. And nobody thinks that those ossify, are limited to the precedent, this court's precedents at the time they were enacted. Everyone thinks that that phrase, due process, incorporates, the developing law of due process and minimum context and so forth, including from this court. So we think that's the best analogy. When you're looking at the constitutional phrase itself, and you take it out of a freighted context, the natural interpretation is say this means, but this reflects the objective meaning of the Constitution. And the objective meaning of the Constitution is its original public meaning in 1866.
Do you see notable counterpoints to that argument?
I'm sure there are arguments on the other side. We address them in the brief.
So you really, at the end of the day, then, this is a straight-up constitutional ruling you want from this court, win, lose, or draw.
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling. If the court's going to do that on a statutory basis than a constitutional basis.
But if you just disavowed that in your responses to it by saying that that's not an available option, is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment, subject to the jurisdiction thereof, as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are, on their face, different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point, and this court has held in multiple cases, Heard against Hodge and General Building Contractors, has recognized that they were intended and they did mean the same thing, and that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous. And so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing, and that is what this court's case law has reflected.
Why didn't they say the same thing?
Again, it appears they prefer the sort of positive formulation subject to jurisdiction thereof as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Juan Kmart, one might have expected Congress to use a different phrase if it wanted to try to disagree with Juan Kmart on what the scope of birthright citizenship or the scope of citizenship should be. And yet Congress repeats that same language knowing what the interpretation had been. So how are we to think about that?
I think baked into that question is an understanding, I think that was reflected in Justice Kagan's earlier question, that everybody understood that Juan Kmart meant that, and the history I talked about, I think, refutes that really there's a consensus that goes our way for decades and decades after the adoption of the amendment and after Juan Kmart on the specific question of the children of temporary visitors. And it's really not until, and again, their author in 1921 is saying, hey, the other side is the consensus.
I'm sorry.
Sorry, go ahead.
But there's executive branch interpretations and others, and if you're in Congress in 1940 and 1952 and you want to limit the scope of Juan Kmart or to eliminate ambiguity, why do you repeat the same language rather than choosing something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think if you look at the structure of that statute, where it's 1401A and then B through H, A, and it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has super added to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the Citizenship Clause, and B through H are the ones that Congress has added to its naturalization power. So that inference to me says, A is not trying to change or alter the constitutional standard. Just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation? Does that give Congress room here, or do you not think so?
I do think that a ruling in our favor would leave room for Congress. I don't think you'd have to rely on Section 5. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals that they say should be covered, Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof, or to define that? Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented, because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here, but obviously we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. So why should we be thinking about, even though as a policy matter I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this? Doesn't that, I guess I'm not seeing the relevance as a legal, constitutional, interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side of there, and Miki say, make it prediction, end of the world type predictions, and our point is, it's a very small minority country. Almost every country, and certainly all European countries.
What do you mean by that, F.B. Jones?
The other side, last one, the other side relies heavily, of course, on Wonka and Mark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wonka Mark that the holding relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this, and then the majority's like, well, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also, domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domiciling Nick Rowe against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wonka Mark that we discuss. We think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wonka Mark.
Thank you.
Justice Barrett?
General Sauer, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil. Jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish, you could say, well, we're going to follow jus sanguinis because we're going to make it all right on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the use solely kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as a soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional use soli rule and a narrower view of the use sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do, and I say I think the right way to conceptualize it is much more. It is a modified use soli, because even the British sources don't just say you're born here, you're a citizen. They say you're born here, and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents; it's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of
It seems a little ambiguous, and I'm going to ask your friend on the other side of that question.
Let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance. We have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Patel talks about, where it's like, who's the citizen? That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates, but they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes of the late 1700s reflect that. And again, look at the 1868 congressional report that we cite. There, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called families? The thing about this is then you have to adjudicate if you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about...
Yeah, but what about the Constitution?
Under the Constitution, look, domicile is a constitutional statement in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and the personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And the virtue of both use soli and use sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to, because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present?
Good morning,
or do you have an
Melanie.
illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously, domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court, and Casa said the agency would go forward to issue guidance, the guidance provides, I think,
Good morning,
very
Janet.
clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to requiring us to do at least these two things. One is believe that the framers were not importing the common law rule an understanding of birthright citizenship. And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those two things. One of which, I think, is that when we look at this court's case law, and no one, I think, has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted, at the time of the ratification of the 14th Amendment, that the allegiance that you're talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 in the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States, whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate, and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade, where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Senator Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, etc., etc. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that concept, or that exchange, strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right, because obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, they're children who do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that, to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are, and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it's well understood that, for example, children cannot, newborns cannot form domicile, so it follows every 19th century.
That assumes domicile is in the test, and I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
When you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, you say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Muller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive...
Which one, the male or the female,
From the
Deborah?
1930s.
How does the temporary presence run
That's
with
Justice
the concept of
Jackson.
allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not. They have that allegiance, and I think it's powerfully
On the basis of what?
domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance, but if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What do you do with Juan Kim Art's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary local allegiance, you're a citizen. And immediately before that, you have that page 693, summary of the court's
Our
holding.
laws say that would make them a citizen.
Incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get
not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
Now, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system, there's computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel. Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you. Everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no.
He should
30
not
years
make
after
sense, Janet.
ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a
Good
fatal
morning,
concession.
Marie.
Because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the U.S.-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a U.S. citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being U.S. citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So, as I just said, all of the exceptions involve situations where that U.S.-born child is not subject to the jurisdiction of the United States because that extraterritoriality, the fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other U.S.-born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance, and those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The 14th Amendment was to embrace the universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too, but then what are those 20 domicile words doing there? Like, you can, take some of them and say, I don't know, they were just summarizing the facts of the case, but not all of them.
It's all BS at the end of the day, y'all. You're right.
Why did they sprinkle that?
Because majority of these people
Well, I
will
think, again,
be
that was those were the
deported.
stipulated facts in the case, and it's
She would
clear
be deported.
We have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions, with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case, and he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, and it ends by coming back to the question.
Dark and brown skin of their birthright citizenship that were born from slaves. No, he's saying that that's the only ones that have birthright citizenship. That's what I think. That's how I took it. That the citizenship is only for babies of slaves. Everybody else, which would include himself, does not have birthright citizenship.
So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something it's something irrelevant that he wanted to throw in. It's like whether a child born in the United States or person.
So again, we safe.
Who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco.
Now, the 50 Shades, the darker skin of the 50 Shades of brown is safe. It's the other people that's not.
The second
so that means he not safe.
In the case was, which again was an
his wife and kids are not safe.
The rule of decision
based on what he trying to do.
Precedential effect.
But this don't apply to the elite, though.
That Wong Kim Ark decided the case based on
it's only for the poor.
You have to follow
listen, y'all. Let's be clear. This man laws that he's putting in place, he does not classify the elite. It has nothing to do with the elite unless he don't like the elites. Okay? In his mind, the only people that need to be here are the rich, period. do away with the middle class, and they will poison, imprison the poor. Okay? This rule does not apply to him. That's just it. When he says making America great again, is making America slave again to the elites, the chosen elite. We need to recognize it. It kills me when people talk about, yeah, I'm from Trump. Yeah, I'm from Trump. Not realizing that he don't want you here. He's trying to find a way to get rid of you. Shit.
If you follow that rule, you get to the same result for people without domicile. Juan Mark says 6 times.
You're right,
Opinion,
sacrifice.
as well as on the page the government focuses on, that domicile is not relevant. That this,
on that, what do we do with the fact
All of
that
a sudden,
after
is this
Juan
thing
Mark,
moving?
at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required. Now, I know you've got a lot of good stuff on your side too, but
And it blow my mind because y'all, they want to great all the people, sacrifice all the people. It's about removing everybody except Jews.
Harlan's lecture here in D.C. So here's what I would say. All of the government citations in their brief generally either were rejected by Juan Mark expressly, if they predated Juan Mark.
If we're trying to understand how the legal community understood
This is good against evil.
Sure.
It seems to me it's a mess.
So
maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post,
Y'all please hit the like button.
Sites, each one of them is inconsistent with Juan Mark. Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Juan Mark, and of course was then cited after Juan Mark was decided by many authorities, again discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Juan Mark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark, and temporary sojourners' children are U.S. citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again citing Lynch, or Kent, and stating the rule that everyone born in the U.S. is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have an 1896, so a couple years before Juan Mark, but an 1896 State Department regulation, which said the U.S.-born children of foreign nationals are U.S. citizens, excepting only the children of ambassadors. And then you have Marshall Woodworth, who is a U.S. attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
And Ms. Lang, can I offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were not. They were overwhelmingly men. There wasn't an indication that they would stay here. They could stay here. They didn't have permanent homes, and the opinion was drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public, and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson, and as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government
that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know it's a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. Wang, I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereign, separate nations in the American system, if you look at occupied alien territory as territory that's outside the jurisdiction of the United States, and then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country, and even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Queren or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is the sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Kieran, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of U.S. territory. So,
and that's, just to interrupt for 1 second,
sure.
And that is territorial. Sometimes, it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and Inglis tell you that when the British forces are occupying Castine, Maine, no one is subject to U.S. jurisdiction there because Britain is governing Castine, Maine. And Justice Story explains, look, if the U.S. then retakes that territory, babies who are born to U.S. citizens by what he called post limine become U.S. citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were U.S. citizens. And Professor Muller goes on to explain that there are many cases of those U.S. citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are U.S. citizens like everyone else. So again, the touchstone for enemy aliens is.
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in the interest of time, just to focus you, how I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as a tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in Elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject in some degree or respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. The government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true for nationals. If the government were right, that the question is what's the maximum theoretical power the government has, there would be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wang, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the U.S. and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress obviously framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language of both.
Okay, so wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that. Would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who were nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the debate the framers referred to, would not have been citizens either. Because if the only test is whether that U.S.-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be.
Well, in all of those cases, the parents would be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in the slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, Counsel. Justice Thomas? Anything further, Justice Alito?
Just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede,
Hold on, it just disappeared.
Must serve in the Iranian army, correct?
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality. We don't look to other countries' laws in construing our 14th Amendment.
Well, it was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a U.S. citizen. So your primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying? And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the U.S. laws, correct?
That's right. The question that the 14th Amendment asks is whether the U.S.-born child is subject to U.S. jurisdiction when they're born.
Meaning, are they within the U.S. territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals, and that isn't what they're saying.
Exactly. So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Justice Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think actually that the U.S. government argues the case this way, but let's put the U.S. government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the U.S. but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference, and of course the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to a closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that, in fact, the framers did consider the concept and the actual problems of immigration that were coming up at that time. In addition to this, notable exchange between Senator Cowan and Senator Conness, where Cowan says, if we have this citizenship clause as part of the Constitution, we are going to encourage these gypsies, what he called gypsies, Roma, in Pennsylvania, whom he characterized as invaders, trespassers, and lawbreakers. We'll encourage them to come into our country because their children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness himself, an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue of birth without regard to parentage. And the third point I would make is an historical one, which is that recall that at the time the framers are thinking about birthright citizenship, there had just been 15 or 20 years of unprecedented immigration from Ireland. The Know Nothing Party was dominant in the 1850s, just a decade earlier, and they were vehemently opposed to Irish immigration. They believed Irish Catholic immigrants were unassimilable and could never become Americans. But even the Know Nothing Party members of Congress believed that the children born in the United States to those Irish immigrants were citizens like anyone else. That's the intuition that the framers of the 14th Amendment had. Contrary to the government's arguments now, they wanted to grow this country. They wanted to make sure we had a citizenry to populate the military, to settle the country. And they also had an intuition that was consistent with the founding aversion to inherited rights and disabilities.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
On Lynch v. Clark, which you cite several times in the briefing today, which I appreciate, the government's response is that the decision was questioned at the time and went unmentioned in congressional debates about the 14th Amendment. I just want to get your response to that point on Lynch.
Sure, not true, though the Lynch was not specifically mentioned by name in the 14th Amendment debates. It was a couple months earlier in the debates on the 1866 Act, where Senator Senator Lawrence talks about the great case of Lynch versus Clark, where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they discuss the children of temporary sojourners elsewhere without mentioning Lynch.
Just want to isolate a point that you've mentioned, which is if the 14th Amendment used the phrase not subject to any foreign power, give a much tougher argument, and then I think you indicated that that's what they meant, even though they didn't say it. I just want to give you a chance to unpack that, because I think that's
Sure.
if it said that, I think our history would be a little different, and I think the text, even put aside the history, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in three parts. The first is that Wong Kim Ark tells us that the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are
Can I get y'all to hit the like button, please?
U.S. citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make citizens, and we can't make their children citizens. That's ambassadors, and that's very clear from
So
that.
if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens, and that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law, and how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist. I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used the phrase several times in the fiction of extraterritoriality, and could that apply, and if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right. We know that the 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason we know this is that the debates themselves had the framers saying, number one, we are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the Citizenship Clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment Citizenship Clause to admit new exceptions. For all those reasons, the entire history of the Citizenship Clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435-0 in the House, 100-0 in the Senate, and said, we're carving out a new, by analogy to the existing categories, a new exception. Your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is that the Citizenship Clause of the 14th Amendment, again, has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the Naturalization Clause, the power to expand citizenship to other people not covered by the 14th Amendment, and obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we address the constitutional issue? This is the last one. Why would we address the constitutional issue given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Sure. You know, I think we obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that, but of course we're happy to take a win on any ground.
Thank you.
Thank you.
Justice Jackson? I'm sorry, Justice Barrett.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions. And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. Is a tribal Indian born on a reservation today on tribal land a natural-born citizen under the 14th Amendment?
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the
By statute.
Act.
By statute. And so is that because what's subject to the jurisdiction of meant when you say closed set of exceptions? It means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today? So let me just be a little bit clear. Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction in the same way that we were talking about, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure, we know it's closed because the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine another situation. The government's trying to make us imagine another situation, right? They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the use solely theory, right?
Sure, that's right.
Yeah.
I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States, they're trying to say, look, we're gonna manipulate the law either to define domicile or to carve out, to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of the 14th Amendment, and that's that there is another sovereign who can exercise jurisdiction over this person even though they're in the United States. And this gets me back to a question you asked Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's argument and say a foreign national is subject to their country of nationality's jurisdiction in the United States, is actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law. And that's what sets ordinary foreign nationals apart from ambassadors.
Well, no, I mean, I understand. That wasn't quite the hypothetical. I understand that. Let me just ask you. No, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of, we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural-born citizen is? You're saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from U.S. citizenship, and that's what the 14th Amendment captures.
Justice Jackson.
So I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying, but I do think that that seems to rest on a different understanding of allegiance than what was in the English common law, and that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean, I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a U.S. citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law. I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense. Is that the right way to think about it? And if so, doesn't that explain why both temporary residents and undocumented people would have that kind of quote-unquote allegiance just by virtue of being in the United States?
That's absolutely right, Justice Jackson, and that comports with the plain text of the 14th Amendment as it applies to everyone born in the United States other than those subject to the exceptions that were baked in a close set. you owe natural allegiance as a US-born citizen. If you want to look at the parents of those people, and let's say the parents are foreign nationals but not ambassadors, the parents owe temporary allegiance.
Right, so the babies get the permanent allegiance piece of this, and the parents get the local allegiance piece of this. So to the extent we're looking for allegiance, we have it.
That's right.
Thank you.
Thank you, Counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice.
This is
Justice
crazy.
Kavanaugh,
This is
turning
just
to
a
Lynch
waste
against
of time
Clark
to
that
me.
you raised didn't come up when I was talking about. Keep in mind that we said it was questioned at the time. It's questioned by a higher court in the same state, the state of New York, and the Ludlam decision in
right.
1860 specifically said that someone who's traveling or sojourning abroad, though born in a foreign country, is not born in foreign allegiance. So obviously there is tension within that very state, and that's what the contemporary commentators noted. And I make a more fundamental point about that. Lynch is not interpreting the 14th Amendment because it predates it. So it's not looking at the language of the 14th Amendment. It's looking at, what does the word citizen mean, for example, in the clause. So there's an anachronism to their reliance on it. And I think that turns to a point that Justice Alito emphasized. Once you get to that language of the 1866 Civil Rights Act, where Congress said not subject to any foreign power, clearly, we are no longer dealing with the British conception of allegiance because Calvin's case and Blackstone say whether you're subject to another foreign power is irrelevant to whether or not you become a citizen. So, again, the concession that I heard to be made that those two mean the same thing, which this court held in General Building Contractors, that the Civil Rights Act has the same scope as the Citizenship Clause of the 14th Amendment. Once you're saying not subject to any foreign power, Congress has clearly departed from the common law, the British conception of allegiance, that monarchical conception of allegiance. They have adopted the Republican conception of allegiance, and there's all kinds of evidence going back to the late 1700s that that's the way they thought about it.
Hey, Richard.
There was a reference, I think, in my friend's presentation about the Marshall Woodworth treatise from the late 1890s. That treatise also, just like Lynch against Tark, the language they quote is actually describing the case or the law, the status of the law before the adoption of the 14th Amendment. So, but if you actually look at the treatises we cite again, I mean, Wharton, Morse, Justice Samuel Miller of this court, Lesser, Black, Hall, Winchester, Taylor, Westlake, Ballat, there's this consensus going from the time of the 14th Amendment onward, and they're looking at the specific question of temporarily present individuals in the jurisdiction. All those sources say their children are not citizens. And that goes both before and after Wong Kim Ark. You see a similar consensus actually in the congressional debates, where whenever it comes up, temporary sojourners, it's understood, the context indicates it's clearly understood that those children are not citizens. And I would therefore finish where I began with drawing a stark.
It said the case is submitted. What's going on now? That's not gonna make America no more safer. If that's what she's saying, hell, it's the elites that has done more crimes. Oh my God, I can't believe how naive people have been. Birthright citizenship is not gonna make America no more safer and secure than before, because it's not going to apply to the elites, and they have done more harm. In my opinion. What y'all think? Do y'all think the birthright citizenship is the problem with crime? Now that we know all this satanic cut like stuff that's been going on. Thank you, Tennessee, for the gift. Thank you. Ooh. I'm just gonna go with the Kuryakin. Thank you for the silver star. What do y'all think? Do y'all think that deporting the, all those bodies that he is trying to avoid, trying to make it seem like it's this when it's that? Release the Epstein files. That's all I'm gonna say. And then let's decide if we need to deport. Let's release the Epstein files. And how about let's deport everybody who did some harm, broke crimes that's in the Epstein files. Can we start there? That's what I think we should do. Release the Epstein files. Hello, Nicole. Steve, I agree with you 10 billion%. A lot lying on here. Why follow liars? Okay, bye. Wow. Up Trump, and this is an outrage. I agree, Sharon. I have no idea what Nicole talking about. Release the Epstein files, and let's deport everybody on there who has harmed, raped, murdered, stole land, false imprisonment, all of that. Let's start there. Let's start at the top and see what's left. Yeah. Then we'll get down to the nitty gritty. Let's get to the nitty gritty. And I promise you, we're going to get more bodies, more crimes, more injustice with Trump. And his whole family need to be deported. I think it's over, y'all.
Here's how I eat low-carb, high-protein meals every day. These are my lunches this week. Eating carnivore or keto isn't cheap or fat.
We are live from Michael Popak at about country.
This relationship based on, even though I'm a
Okay, yeah, it's over, y'all. I'll be back later. Oh, wow.
Amendment. Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal
It
members.
has been submitted, but let me double check
By
something
statute.
before I go.
And so is that
In the meantime and in between time.
So, if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868, or do we look at it how it's understood today in the context of the INA?
The 1868 understanding, not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1860. We really didn't have laws like that that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
But that's 1898. Now I'm looking at 1868. You're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well, but decisions of this court.
So it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from Wong Kim Ark in 1898.
But that's 1898. Now I'm looking at 1868. You're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well, but decisions of this court.
So it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is applied to...
continually restrict who may lawfully be present more and more, and you would say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile. And so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the child, obviously. It's the parents you'd have us focus on. And, what if, is it the husband? Is it the wife? What if they're unmarried? Whose domicile?
Well, in the executive order, it draws a distinction between the mother and the father. It's really the mother's domicile. I think that would matter.
Well, but 1868 matters, you're telling us, so what's the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868? And do we have to do this for every single person?
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. We have the child's citizenship, and the focus of the clause is on the child, not on the parents. And you don't see domicile mentioned in the debates. The absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form a domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. And I point out that their position, like ours, is forced to look at the domicile of the parents because if you look at the exceptions that they accept, like
I'm talking about
tribal Indians and so forth.
I'm talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many...
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few examples. Page 1679 of the Congressional Record, President Johnson vetoes the first version of the Civil Rights Act, and he says, I can't sign this because it would extend citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources we cited that say, this is a deeply rooted 19th century understanding. It's reflected in the Venus. It's reflected in the Pizarro in 1814 and 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Acts. Domicile is the key concept that creates allegiance. That's
General, you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, lawfully, General, you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And you can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South.
And brainwashed. And he will be
slaves in Mississippi have an indefeasible
subject to this law.
Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. Right, and so it would be astonishing, in other words, for the opponents of the 14th Amendment
I don't think he did nothing legally.
These people were not domiciled, and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there, by
their intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, which says, lawfulness for a different purpose, but they're here, they're resident, let's
even if they were brought in illegally and through an illegal slave trade, once they were there,
their intent is to return as soon as they can, let's say. So they're
Another
here, they're resident, and maybe under your
Absolutely.
theory, which says, lawfulness for a different purpose, but they're here, they're resident, let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I think this is the flip side of the hypothetical that we talked about earlier. Under 19th century law, they are treated as domiciled in the United States, so it'd be astonishing. And the debates in the congressional floor talk about not this specific case, but they say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. And they don't use the ways domiciled like they use allegiance. They say they don't have allegiance, that once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're...
But General, that goes
How would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled.
That trafficking, that's
brought
Trump.
in illegally.
Baby, that release
but
the
then they
Epstein
choose
files.
to remain.
Potentate, and therefore they're...
But General, that goes
How would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
By the elite.
The parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful. In other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
A healthy liver helps your body process food.
All right, Dad, what are you making?
My new go-to morning smoothies. What's that?
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country, where there was quite clearly an experience of, an understanding of, that there were going to be temporary inhabitants. And your whole theory of the case is built on that group. You don't get to talking about undocumented persons until quite later and at much lesser, I think it's like 10 pages to 3 pages or something like that. So you can't really be going with Justice Alito's theory. You must be saying that there is a principle that developed, that was there at the time of the 14th Amendment. Isn't that right?
We agree there's a principle there at the 14th Amendment. It is the jurisdiction means allegiance, the allegiance of and this very strongly reflected in 19th century sources, the allegiance of an alien present in another country is determined by domicile. And that goes back to the Venus and the Pizarro. It goes through the Katza Affair in 1853. It comes right up to Fong Yui Ting and Lau Ao Bu that are decided shortly before Wong Kim Ark. So that's the principle. That principle clearly applies here. I also respectfully disagree.
Yeah, and I guess, Mr. General Sauer, where does this principle come from? Allegiance, domicile, allegiance, I think you point to a Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of when we think of the word jurisdiction, and I appreciate that jurisdiction has many meanings, but the first meaning is like, if you're subject to jurisdiction, you're subject to the authority of. One doesn't say, what that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical, esoteric meaning. And then the question comes, okay, if the text doesn't support you, if there's a real history of people using it that way, but as far as I can tell, at the time of the 14th, you're using some pretty obscure sources to get to this concept.
Well, take it straight from the framers' mouths. So, for example, Senator Trumbull was asked, what does jurisdiction mean? He means subject to the jurisdiction. He said, what does that mean? He says it means not owing allegiance to anybody else. He is the principal framer of the Civil Rights Act of 1866. Representative Bigham, who's the framer of the 14th Amendment, is asked, what does it mean in the congressional record at page 1291? He says, within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. And we've cited many, many examples where the congressional debates reflect that. Then you referred to the oration of George Bancroft. That's one of probably 16 sources, but there's at least 13, counting that one in the 12 treatises we cited, pages 26 to 28 of our brief. There is over a dozen sources that specifically address temporary sojourners. In the 5 decades after the enactment of the amendment, every single one of them says, well, temporary sojourners, their children are not included, including for 2 decades after Wong Kim Ark.
Global Air Cylinder Wheels has reinvented the wheel by introducing an eco-friendly.
So, if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868? Or do we look at it how it's understood today in context of the INA?
The 1868 understanding, not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1868. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
But that's 1898. Now I'm looking at 1868. You're telling me is what I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like world.
And which justices will you be listening for most closely?
I love a few of them. I don't like some others. And you say what you want. But you have the ones that were appointed by Barack Hussein Obama and Biden. I don't care how good your case is. You could have the greatest case ever. They're going to rule against you. They always do. And it's not supposed to be that way.
Thank
the
you.
Republicans tend to be very different. They want to show how honorable they are. So a man can appoint them and they can rule against him. It's so proud of it. We're so proud we ruled against Trump. We're so proud. We're above it. There are those that say that's wonderful, and there are those that say they're so stupid.
They're so stupid when they rule against me, but so wonderful when they don't. President Trump yesterday in the Oval Office after announcing he will attend the oral arguments this morning at the Supreme Court for his executive order challenging birthright citizenship. Joining us now, former U.S. Attorney, former senior FBI official Chuck Rosenberg. Also with us, Norm Eisen. He's the executive chair of the Democracy Defenders Fund from 2019 to 2020. Served as special counsel to the House Judiciary Committee for the impeachment trial of President Trump. He's also co-founder of the Contrarian on Substack. Gentlemen, good morning. So glad to have you both here. Chuck, I'll start with you. You'll be outside the chamber, I know, this morning covering this for us. Just if you can, set the stage a little bit for people who are just kind of tuning in to what the stakes are in this case.
The stakes are high. Let me back up a little bit, if I may, Willie, and give you some history. I know it's early for history, but here we go. Yeah, so in 1857, the Supreme Court decided what turned out to be one of its most repulsive decisions, Dred Scott. Dred Scott stood for the proposition that black people never were and never could be citizens of the United States. A truly repulsive decision. In 1868, we enacted the 14th Amendment, primarily to address the Dred Scott decision, primarily to make sure that black people could be and always would be citizens if born in the United States. What's at issue now, what will be argued later this morning in the Supreme Court, Clause 1 of the 14th Amendment, the so-called Birthright Citizenship Clause. The question is whether or not somebody who is born or naturalized in the U.S., and this is the key phrase, and subject to the jurisdiction of the United States, is in fact a United States citizen. There's old Supreme Court law on that question. It will be tested today. And the question going forward, of course, is whether somebody born in this country, perhaps to an undocumented parent, will continue to enjoy the privileges of citizenship. So big question, big day, big argument in the Supreme Court, Willie.
So, Norm, your organization, Democracy Defenders, co-counsel to the ACLU in this case, challenging Donald Trump's use of the executive order here and defending the 14th Amendment. This is not the first time that a case like this in this case challenging Donald Trump's use of the executive order here and defend
for the privileges of citizenship. So big question, big day, big argument in the Supreme Court, Willie.
So, Norm, your organization, Democracy Defenders, co-counsel to the ACLU in this case, challenging Donald Trump's use of the executive order here and defending the 14th Amendment. This is not the first time that a case like this around birthright citizenship has been argued before the Supreme Court. What is the case you all will be making today?
We will make the case that since the founding of the United States, it's been understood that the children of migrants born here are citizens. That's an ancient tradition in Anglo-American law. It was reaffirmed in the 14th Amendment. There's no real serious question about that. And that was confirmed, Willie, in 1898 in the Wong Kim Ark case. So this has been good Supreme Court law for over a century. Congress has passed a statute reaffirming this. And until the farcical, intellectual gyrations of Donald Trump, where he doesn't follow the law, he thinks the law should follow him, nobody seriously questioned that the children of migrants born in this country were citizens of the country. Donald Trump doesn't get to choose which babies born here are citizens. The Constitution and the 14th Amendment make that choice. I'll be in court with the legal team today, and I'm looking forward to Donald Trump hearing directly from a majority of the justices on the Supreme Court bench that these arguments he's making, like so many of his other attacks on the rule of law, fly in the face of the Constitution and our laws.
Chuck, one of the points that the president likes to raise is that this is an anomaly in the United States. Most other countries, most Western democracies do not have birthright citizenship. I don't think that makes any difference in terms of what the Supreme Court justices are going to feel about this case or think about this case. Would you expect there to be a 9-0 ruling on this? Because critics of the president say this is such a clear breach of the Constitution that anything short of a 9-0 ruling would be something of almost of a loss for liberal principles.
So two responses, Caddy. First, roughly 30, maybe 32, 33 countries have a analogous birthright citizenship clause in their law, their constitution, primarily in the Western Hemisphere, so North, South, and Central America. But you're quite right. Many other democracies do not. But that's not determinative. And I know you understand that. I mean, our laws, our Constitution will inform the judgment of the court today. Do I expect it to be 9-0? I don't. When the Wong Kim Ark case was decided in 1898, the one that Norm had referred to, that was a 6-2 decision with one judge, one justice abstaining. There's always been some contest around the words, subject to the jurisdiction thereof, and what does it mean? Unanimity would be nice. I don't fully expect it, but I think Norm is right. We have a common understanding of what the 14th Amendment is and does. We do have a Supreme Court case that is almost entirely on point, and we have Congress in 1952 enacting a statute that echoed the words of the 14th Amendment and guaranteeing this right of citizenship. Will it be unanimous, though, Caddy? Not so many things are these days.
He's a born idiot. That's what his mama said.
There were a slew of rulings against the president yesterday in federal courts. A judge ordered an immediate halt to the construction of President Trump's 90,000 square foot White House ballroom. The judge ruling that the president lacks the authority to fund the $400 million project through private donations, adding that Trump has no statutory power for a project.
He a guest in that house. It's not his house. He don't own it. But hell, they better check. He may have messed over a deed.
Not so many things are these days.
All right. So
he think it's his house. He think the White House is his.
Yesterday in federal courts. A judge ordered an immediate halt to the construction of President Trump's 90,000 square foot White House ballroom. The judge ruling that the president lacks the authority to fund the $400 million project.
Yeah, he can't even get a surety loan, bond.
Has no statutory power for a project of this scale.
Faking the funk like he got money.
Let's take these one at a time really quickly. And just Chuck.
Trying to file bankruptcy.
You know, it's the sort of thing where Donald Trump decides one day to tear down the East Wing of the White House, and Americans go, can a president just tear up the White House and rebuild it by himself? And of course the answer is clearly no, but we do have a legal process. It took a while for the courts to
but he shouldn't have touched it.
Talk about this
until he had a ruling.
As I say, Donald Trump pushing out at the boundaries of his Article 2 powers, and the courts now, it seems, have finally caught up to all of that. You know, there was a Project 2025. There wasn't a Project 2026 because the courts seem to be running Project 2026, which is a constitutional correction, an illegal correction of all the abuses that occurred in 2025.
Yeah, Joe, so there has been over time, last half century, if I may, an accretion of power in the executive. At the same time, we see Congress ceding its power over and over and over again. Congress failing to act as a check on the president, whether it's in terms of funding, whether it's in terms of war-making authority, right? Congress has ceded the field to the president. So if you want to check a president, I'm not just talking about Mr. Trump here, but if you want to check a president, the place you go is to court, right? It was interesting to me, for instance, that President Trump simply ordered that TSA workers be paid. I'm all for paying TSA workers, but normally, as you know, as a former member of Congress, that's done in a different way. And so to the extent that Congress is not doing anything,
hey, Lisa.
and I mean that strictly in a bipartisan way, it's not surprising to me that President
they tried to stop it before. He never should have started.
More and more through executive order
until he had clearance. His whole thing is to tie shit up in court to get his way, and by the time, you know, they get a decision, it'll be too late.
Your last name. I keep thinking of Abraham Lincoln's line to Congress, that famous line to Congress in 1862.
This administration is about their interpretation of the law and tying it up and stalling it out until whatever he wants done is done.
Every time I see an American leader arrogantly proclaiming victory, they don't need to go back 1,000 years. There's always blowback in the Middle East, and I'm just shocked that we're not hearing more of that out of Israel or the United States. Give us your thoughts on that and what that blowback may look like.
Well, I think you're right to bring up a historical
I hope he don't start it back.
What we do on the news, quite
he does not follow the law.
Focus on the comments
he don't have no respect for it unless he wants it, unless it's a benefit to him.
At 9 a.m. and the thing at 2 a.m. is...
Other than that, the law don't mean nothing.
We'll just kind of say anything. But from a historical point of view, what has this added up to? We had a nuclear deal with Iran. We have no illusions about Iran and its dangers it presents to the region, but we had a nuclear deal, however imperfect, that Donald Trump walked away from.
Oh, I believe that. Is that what Diddy did? Hi, Danny.
He walked away from it. And now we, in the 6th year of a presidency that's increasingly erratic,
look at that clown there.
Corrupt,
oh, that's that reptilian. Look at them eyes.
We have a president that's now intoxicated with the use of American military force. It's not the first president to be so. And whatever negotiations he has are being conducted by Jared Kushner, Steve Witkoff, two people who are deeply involved in enriching themselves in the region, which is unprecedented. And so an American is left with witnessing this and paying for it, both financially and in the danger that it presents to our people in uniform, and has to wonder what the hell
he your God, Cynthia. He not mine, he the devil.
What is this presidency
presenting
for us?
And
You
I think
lose,
it's just
Trump,
a
man, you
deeply
lose.
dangerous time in American
Oh, you
history.
saying
And
you
you
lose,
know, I
Trump
think that
lose.
Donald Trump has
I
presented
thought you
an
were saying, I
emergency
misread that. I'm
for this
sorry.
country for a very long time, but it's gotten deeper and deeper.
He is most definitely a
David, I want to read
loser.
a little of your recent
Hey,
piece on Iran. You write
Gerda.
this, quote, "The cruelest irony is that the president who addresses the Iranian people in the language of liberation, urging them to throw off the yoke of a regime that has brutalized them for decades, he's the same man who threatens American journalists with treason charges and tries to strong-arm broadcasters into subservience. Having torn up a nuclear agreement in his first term and gone to war with no
He is
coherent
the
goal in
Satan,
his second,
absolutely.
Trump now directs his fire at the one thing he cannot afford to leave standing, the truth. What's at stake is democracy's oldest promise, that people may call on their government to answer for what it does in their name." And if you just look at public polling, David, they're not quite sure, the American people, that you write about what this war is all about. They're told on the one hand it's about regime change, on the other hand it's about crippling the nuclear capability of Iran, and then on the other hand it's degrading the military capability of Iran to strike and hurt our neighbors in the Gulf and also in our allies in Europe as well. So the lack of a coherent strategy amounts to the American public going,
Biggest flop,
largely, what
a
are we doing in
flip-flop
Iran?
policy
Well, they were never
of
consulted.
any
Congress was
president
never
ever.
consulted.
Absolutely,
The day
Spartan.
before President Trump announced
But it's because of the Epstein files.
Iran
He
with
crooked.
Israeli forces, he was in negotiations, and the foreign minister of Oman had said that there was real promise there. Again, I have no illusions. No one
Biggest
has any illusions, I hope, about
criminal
the nature
organized crime cover-up
Iran's regime and its
ever.
capacity to lie and to be extremely difficult to deal with. The fact is, we have dealt with that same regime, and we did come to a nuclear deal.
Hi, Angelica.
And you don't make treaties with your friends; you make them with your enemies through.
Please
long,
hit the like
tough,
button, y'all.
complicated
Please hit
negotiations.
like, share,
We seem
and
not to have
subscribe.
the
Get a
stomach for
membership.
that, or the skill or the will for that, and we did what was close at hand. We sent in the bombers, and I have no doubt about the skill of the purely military aspect of this. There was an opportunity. Iran was extremely weak after the 12-day war last June, and with free skies, we've been able to, quote-unquote, take out one installation after another, all the while forgetting that human beings are being killed. And toward what end? Was there really the illusion that this regime was just going to be toppled by an opposition that unfortunately is not organized and would have faced, being mowed down in the streets? These are illusions conceived by people that just are not realistic about what's present in Iran and what was possible. And at the same time, our leader, the President of the United States, is perfectly willing to BS his way through every press conference and change the subject and start. Iran was extremely weak after the 12-day war last June, and with free skies, we've been able to, quote-unquote, take out one installation after another, all the while forgetting that human beings are being killed. And toward what end? Was there really the illusion that this regime was just going to be toppled by an opposition that unfortunately is not organized and would have faced, being mowed down in the streets? These are illusions conceived by people that just are not realistic about what's present in Iran and what was possible. And at the same time, our leader, the President of the United States, is perfectly willing to BS his way through every press conference and change the subject and start talking about his magnificent new ballroom. It beggars the imagination after a while. Historians will not be kind to him or this. And I think the American people, in greater and greater numbers, are seeing the light, to be perfectly honest.
So as David said, President Trump never really made the case for this war, but Mike Barnicle tonight, he addressed the nation. In 9 o'clock primetime address, we assume from the Oval
Do
Office.
we really want to listen to that mess? I know I don't, because he going to blame the Democrat.
He will make
He
this
going to
speech,
blame, who he
and
going to
where he finds himself
blame?
really boxed in with two choices. One would be to escalate the conflict, including perhaps with ground troops who are now in the region ready to go if he gives the green light. That would be a risky operation. American lives would be lost and also likely to be politically unpopular. Or he walks away, whether that's in 1 week, 2 weeks, 3 weeks, whatever it might be, perhaps with not actual regime change, but the Strait of Hormuz is still in Iranian control, which would be an economic blow, not just to the U.S., but to the globe. So, President tonight, it is a war of choice, and these are problems of his own making.
Yeah, but Jonathan, you're describing someone who has a theme to what he's doing, who has some sense of what he's doing. What we have is a man who is so erratic and has been so erratic, and his inability to stop talking 2, 3, 4, 5 times a day with different positions on the fact that he's talking about war is unnerving. To David Remnick's point, I was speaking with someone yesterday who is well-versed, has been well-versed in both diplomacy and the politics of all things like this for over 20 years. And this person was telling me that in his estimation, the credibility of the United States has been so far diminished over the last 18 months that it's unnerving. That the Arab states now feel as if they're on their own, given Trump's behavior, in his erratic behavior over the last 18 months. That what's going on in the Mideast has ironically made Iran stronger in the view of this person who I was speaking to. That the theocracy is not going to go away. That the country is not going to change. That the leadership of Iran, no matter who's gone and who's still there, they still have the capacity and the will and the determination. They just killed 30,000 of their own people 2 weeks ago. That's what they're going to do if push comes to shove. And Joe, he ended up by telling me that the idea that we would walk away from the Straits of Hormuz is the most irresponsible thing and the most dangerous thing that he's heard from an American leader in decades.
I find it hard to believe that we will actually do that. The possible cascading effects, geopolitically, economically, are unfathomable. David Remnick, we've talked about the United States and President Trump. You've written about Benjamin Netanyahu as well. I think many have been deeply concerned. I certainly have expressed my concerns about, as a longtime supporter of Israel, as what Benjamin Netanyahu's policies, what his forever war, what his a leveling of half of Lebanon after declaring Hezbollah defeated in 2024, what happened in Gaza, and what continues to happen. Marco Rubio saying that Netanyahu dragged America into this war. For supporters of Israel, let me guide it this way, for supporters of Israel that are listening, like myself, what are the long-term negative impacts on Israel as a nation, specifically, and the neighborhood it lives in generally over the next decade?
Well, the moral damage done to itself, to Israel, it begins with the damage done to other human beings. What was done in Gaza was so beyond excessive, so horrific that I just don't think we have taken in how damaging that would be. Again, obviously, first and foremost, to the Palestinian people, but also to Israel itself. And now a lot of political forces in Israel are talking about, quote, doing Gaza in the south of Lebanon. And I just don't know where it ends. And at the same time, you have elections coming up in Israel. And I don't see any prospect for dramatic change, because either Netanyahu will find a way to win, and he's extremely skilled as a politician and as a campaigner, and support for this war in Israel runs very high, or somebody like Naftali Bennett will come to power, quite conceivably, who is no less right-wing on these issues. And the only thing he doesn't have hanging around his neck in quite the same way is the security failure of October 7th, 2023. So Americans should not expect dramatic change in the leadership of Israel. I mean, I don't see that happening. Are there security concerns for Israel? And there always been for the length of its existence? Of course. But was this wise? Is there a morality to the degree of this this action in Lebanon? I can't see it, and I think that will be, in the end of ends, extremely damaging.
It's hard to tell at the moment, Joe and Mika, exactly what the fallout will be from this Iran operation, but the degrading of the relationship going forward between Israel and the United States looks like it's going to be one of them. The problems in the relationship between the Gulf states and America that this has caused could be another. And then you look more globally, and the winners from the conflict so far, China and Russia, the two countries that actually pose the greatest threat to the United States going forward. So however this ends, there has certainly been a shakeup, not just in the region, but potentially even in the global balance of power as well.
All right, editor of The New Yorker, David Remnick, thank you very much for coming on this morning. We'll see you soon.
Please hit the like button.
Hey, it's Ashley with 4 Patriots. We're in a bit of trouble. To put it plainly, we need to clear out some space.
That was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens.
Donald Trump continues to panic all morning long as his disastrous war in Iran continues to escalate. Donald Trump is now saying he wants the United States to withdraw from NATO. Donald Trump gave interviews with the Telegraph and with Reuters.
He didn't get the support. His feelings hurt.
He wants the U.S. out of NATO. He says NATO is a paper tiger. He said that he and Vladimir Putin talk all the time about how NATO is a paper tiger and is useless. Donald Trump then attacked the Navy for the United Kingdom and said they're useless. They don't even have a Navy. He attacked Keir Starmer, and Donald Trump told Reuters that in an address to the nation that he's supposed to give tonight at 9 Eastern, 6 Pacific, he may make the case why the U.S. should be out of NATO. Now, there is a law that was signed by former President Biden, which says that unless there is a 2/3 vote in the Senate, a president can't unilaterally withdraw from NATO. By the way, you know who sponsored that bill which became a law? Yeah, it was Marco Rubio when he was a senator, and Senator Kaine. It was a bipartisan bill, and now, of course, Marco Rubio working with Donald Trump to pull the United States out of NATO. And Donald Trump and Netanyahu went it alone in this catastrophic war against Iran. They didn't consult any allies. Donald Trump didn't talk to NATO before the invasion. He didn't talk to allies in the Middle East. And then he just invaded Iran. There's a quagmire now where Iran now controls the Strait of Hormuz. Iran continues to strike its Arab nation neighbors where the U.S. has military bases and interests. Heck, last night, as I reported this morning, we can confirm this now, Iran hit an Amazon facility, an Amazon data facility in Bahrain, which is exactly what Iran said it was going to start to strike American corporate interests now in the region as well, despite what Donald Trump and his sycophants say, where they go, Iran's been totally decimated, Iran's been totally destroyed, they don't exist anymore, they don't have leaders. That's completely and utterly false, and Donald Trump will be addressing the nation tonight. Who knows what the heck he's going to say. Lots of people also believe that Donald Trump may be saying he's going to withdraw from Iran and just let our, former allies deal with the problem with the Strait of Hormuz. We're just going to bail on it. We're not going to do anything because as we head into Easter this weekend, the stock market closes down on Friday, and so perhaps Donald Trump will try to do a ground invasion.
Italy would allow
disinformation
U.S.
that's being
planes to
spread
land on a
as a way
basis
to
or would
do a
not.
ground invasion. But the reality is Donald Trump lies about absolutely everything.
Everything.
This has been a catastrophic war on every level. I mean, even this morning, Donald Trump posts on social media to manipulate the market. Then he tries to spread this message to Axios and others. He goes, Iran's president has demanded that we enter into a ceasefire. They're begging us for a ceasefire right now. And then Iran's foreign ministry said, that's not true. We're not asking for a ceasefire. We do not want a ceasefire. I mean, what Iran has said is that they would be willing to end the war, because it takes two to end a war, multiple countries, if multiple countries are involved in the war, if they have security guarantees, real security guarantees, reparations for the war. They can keep their ballistic missiles. They won't be prohibited in the future from enriching uranium if they want to. And they want American military bases out of the Middle East. They said those are some of their non-negotiable points. Oh, and they continue to control the Strait of Hormuz. And Iran continues to say, not only have we not offered a ceasefire, we're not having negotiations. Now, Iran's foreign minister said, look, the Trump regime tries to reach out to us, whether it's through Pakistan or whether it's directly, and they want a ceasefire. They want to end this thing. But Iran says that's not a negotiation. We have not agreed to any framework of a negotiation. We have completely rejected the U.S. 15-point plan, and we've made clear what our non-negotiables are. We're the ones who will set the deadlines, not the United States. We will not be, we will not have to bow down to arbitrary deadlines, is what they're saying. And I want to point out as well that we also saw a lot of world leaders addressing their nations right now to talk about the shock to the oil supply and the harm that's about to unfold. It already is unfolding, but world leaders are preparing their countries for what's about to take place. Anthony Albanese in Australia addressed his nation earlier today, saying it's going to be very difficult in the months ahead. I mean, the shock, even if the war were to end right now, which it's not going to, the shock to the oil supply, the shock to fertilizer, helium, just lots of stuff in general. The shock to the supply there is going to have this cascading effect, even if the war were to end. And Australia's Prime Minister Albanese preparing his people. Meanwhile, in the UK, Prime Minister Keir Starmer addressed the people of the United Kingdom as well. He addressed his country, and he said, look, this is not our war. We're not getting dragged into it. Donald Trump has tried to bully me over and over again. I'm not going to be bullied. We're not being dragged into this war. Donald Trump's tactics are not working. So we've seen it. Let me just pull out the receipts, as we do here on the Midas Touch Network. I'll go piece by piece. Just a reminder, hit subscribe. Help us get to 7 million subscribers. While you're at it, subscribe to Scott McFarlane's YouTube channel. As you know, Scott McFarlane joined the Midas Touch Network, and his YouTube channel is just soaring right now. Okay, the front page of the Telegraph this morning was Donald Trump saying, I'm strongly considering pulling the U.S. out of NATO. Again, as I mentioned before, he said that he blames NATO for what's going on right now in Iran, for not joining him after he initiated the war without telling anybody other than Netanyahu. He said NATO's a paper tiger. He said that Vladimir Putin tells him, direct quote, Vladimir Putin knows that NATO is a paper tiger. And so I agree with Putin. Putin says that, is what basically Donald Trump is saying. Donald Trump said the following on NATO also. Of course, Trump has to attack Ukraine. We've been there automatically, including Ukraine. Ukraine wasn't our problem. It was a test. And we were there for them. And we would always be there for them. But they weren't there for us. Right? Even right now, as President Zelensky of Ukraine tries to help the United States and say, hey, I've got the drone interceptor technology. Ukraine probably has the advanced drone offensive and defensive systems in the world, not just the technology, but the know-how, how to deal with them. I mean, I think I saw Ukraine's interception rate is over 90% in the month of March of the ballistic missiles and drones now.
that Russia is using, which are made with Iran. And Donald Trump continues to attack Zelensky over and over again. And Trump continues to lift oil sanctions on Russia, lift sanctions on Russian vessels, invite the Russian Duma to Congress to meet with MAGA Republican Congress members, as well as with the State Department, while we all know that Russia's helping Iran in the war. And Donald Trump is out there helping Russia and hurting Ukraine. It's just that simple. Like, it's very, very clear. We don't have to be hyperbolic. That's just what I just said there are undisputed facts of what is happening. Then here's what Donald Trump said about Keir Starmer, the Prime Minister of UK. He can do whatever he wants. It doesn't matter. All Starmer wants is windmills, costly windmills that are driving your energy prices through the roof. Then Donald Trump posted on social media. Iran's new regime president, much less radicalized and far more intelligent than his predecessors, has just asked the United States of America for a ceasefire. Didn't happen. Not true. 100% false. Never happened. Donald Trump goes on to say, we will consider when Hormuz Strait is open, free and clear. Until then, we are blasting Iran to oblivion, or as they say, back to the Stone Ages, DJT. And again, blasting them to oblivion, back to the Stone Ages. As I think I said on the podcast I did with my brothers on Monday, or maybe I said it yesterday during a live podcast, he sounds like the bad guy, like a corny bad guy from some cartoon I watched growing up. We're going to bomb you to the Stone Ages. All you're doing is further building resilience amongst the Iranian people, who are very proud cultural heritage people. Even if they didn't like the Ayatollah, and perhaps I'm putting that lightly, you're just creating them to have more solidarity in fighting back right now by when you say things like that as well. Iran's foreign ministry responds right away. Trump's claims that Iran requested a ceasefire are baseless and false. And of course we know they're baseless and false because there isn't a ceasefire. Iran continues to strike its Arab neighbor nations in retaliation. It also strikes Israel, successfully hitting Tel Aviv and other areas. And Iran's shooting less ballistics and using less drones, but more precise strikes is what's taking place. They still control the Strait of Hormuz. It has a leadership structure in place that's actually more
out the country first, then worry about other things.
For controlling the Strait of Hormuz and not ending the war than what the prior leadership was. But still, the Islamic Republic, it's a complete catastrophe for the United States.
You didn't care about energy under Biden.
UK. You don't have
Well, we're not under that administration, Paul. We're talking about right now. We're talking about what's going on right now.
Involving the Amazon facility.
Yeah, and shit you can do about what happened under Biden, but we can make some changes now. Let go of the past.
Continues to get hit.
Stop drinking the Kool-Aid.
Off the coast of Dubai. Got hit.
You too old for that.
Defense Ministry said that 3 missiles were launched from Iran.
Yeah.
Adding that while 2 were intercepted,
get your hand out of Trump's diaper, baby. That's not a cute look on you.
Energy in Qatari waters. Now, Qatar Energy already declared a force majeure.
I'm talking about right now today.
20% of its facility, its LNG facility, has already been shut down as a result of the Iranian strikes.
I'm sure it's Biden's fault because he started the war. It's everybody's fault except the person whose fault it is.
Remember, that was like a week and a half
Grow
ago.
up.
So Qatar Energy is reeling.
I'm so sick of people like
Qatar
you.
When you give Donald Trump a jet,
You're the problem.
A big jumbo jet, and you get as Donald
You're
Trump
absolutely
would say,
the
bomb
problem.
to the Stone Ages or bomb to oblivion right there. As I mentioned,
But hit the like button.
With the Reuters folks as well. Trump told Steve Holland in a brief interview he will express his disgust for NATO at tonight's speech and that he is absolutely considering withdrawing the United States from NATO. Trump says the United States will be out of Iran pretty quickly. And then Donald Trump said we may still
people who need excuses that don't take ownership rely on something else that happened. That's what they call that, moving the goalposts, gaslighting. Stay focused.
The last 2 times there were negotiations,
Stay focused.
Trump used the negotiation to invade in the middle of a negotiation where there were, by all accounts, based on the independent mediators in the room and other independent sources in the room, like the British National Security Advisor, that there was a deal to be made. And perhaps a deal to be made that was stronger than even Obama's deal. But Trump and Netanyahu invaded anyway. And, everything since then has continued to escalate and escalate. And, and so why would Iran want to even do a negotiation in the first place? Why would they want to do a ceasefire? Why would they want, if they know that the U.S. is just going to build up and do spot hits? No matter what. That's why they said we need security guarantees, because otherwise this is going to keep on happening over and over again. We know that the United States munitions and Israeli munitions are running out. They know that. It's not like a secret to them. They're aware. They know how unpopular this war is in the United States. It's not a secret to them. Why would they agree to a ceasefire when they could drag this out for many, many, many more months and cause more pain if they're not going to get anything in return? I mean, that's just one of the things right there. Meanwhile, Donald Trump's approval, according to a new CNN poll conducted by SSRS, how Trump is handling his job as president: 35% approve, 64% disapprove. Similar to, I think it's lowest in the CNN poll. We saw the UMass Amherst YouGov poll where Trump's approval was only at 33%. You look at CNN's poll on Donald Trump's handling of the economy. Right now it is at 31%, 69% disapprove. I mean, these are truly just horrific and ugly numbers for Donald Trump. I'll just show you quickly what Prime Minister Keir Starmer said on Iran. These are very short clips, but I want you to hear what he said. Here, play this clip.
Well, it's very important that we're clear. There's been a good deal of pressure on me to change my position in relation to joining the war, and I'm not going to change my position on the war. So whatever the pressure, whatever the noise, I'm the British Prime Minister and I have to act in our national interests.
And here's what he said about Trump trying to put pressure on him. Let's play it.
Well, I do think that we should strengthen our cooperation on defence, security, energy, emissions and the economy. And on the economy, the steps we've taken so far have been in relation to the single market, and I'm ambitious that we can do more in relation to the single market.
And ultimately, for Keir Starmer, it's about strengthening the relationship of the UK with the EU, moving away from, the special relationship with the United States, European Union, Ukraine, Canada, Australia, forming a strong bond. I think NATO pretty much only exists right now in name only. While it's sad to say that, Trump delusionally believes that he is allied with Putin while Putin helps Iran destroy the United States. And, there was this front page of The Economist that has Xi Jinping on it. And the front page from today says, "Never interrupt your enemy when he's making a mistake." We spoke to, The Economist writes, we spoke to diplomats, advisors, scholars, experts, current and former officials in China. Almost all of them see the war in Iran as a grave American error, and it's, just significantly benefiting China, Russia, and Iran. So what's the U.S. doing today as well? The U.S. is now once again trying to attack Denmark and Greenland, saying that the U.S. wants access to 3 additional sites. So back to attacking Greenland right now. They're going to bring that up again. And I'll do another take on this, or Popak will do a take on this this morning. There are oral arguments right now in the Supreme Court case where Donald Trump signed an unlawful executive order to get rid of birthright citizenship. The case is called Trump versus Barbara. The 14th Amendment of the United States Constitution sets forth that people who are born in the United States are citizens of the United States. By an executive order, Donald Trump is saying that that is unlawful. Donald Trump's executive order is what's unlawful. There's also a statute, 8 U.S.C. Section 1401, a case called Wong Kim Ark, which says that birthright citizenship is the law of the land in the United States. And at least as of now, even from the right-wing Supreme Court justices, they do not think that there's any merit to Trump's executive order. And it seems that Trump's going to lose, and Trump's actually in the Supreme Court right now watching what a loser he is. So we'll keep you posted, of course, on all these things throughout the day. Hit subscribe, help us get to 7 million subscribers. We appreciate you as always. Want to stay plugged in?
Let me see what else we got before I go. Hold on, let me see what this
This
is.
is Congressman Eugene Dimon. I made a tough decision this weekend, and I'm asking if you can chip in to help me see it through.
A very furious Ukrainian President Zelensky is striking back hard and checkmating Donald Trump in public as Donald Trump removed sanctions against Russian oil. And then just yesterday, Trump removed additional sanctions against Russian shipping vessels as Donald Trump continues to attack NATO and say that after this war is over, Donald Trump's catastrophic war against Iran, we're going to pull out of NATO, or we'll see what we're going to do about NATO. Zelensky is uniting Europe and making it very clear, not only is Ukraine part of Europe, but Ukraine is going to be a leader in Europe when it is welcomed into the European Union eventually, and it should have already happened already, in my humble opinion, but that Ukraine is providing the security umbrella for Europe, and that a strong European security umbrella could allow Europe to become a leader of the free world. And by the way, I wouldn't be shocked if that aligns with kind of the Canadian military interests as well, and then some of the interests in Asia that Mark Carney is helping to unite. And I think Zelensky is a critical and pivotal player in that. Let me just show you what went down over the past 12 to 24 hours as well. I mean, it's one of the things that Zelensky's been repeating, though, is he goes, what do you think about Donald Trump liking you, or does he like you? Zelensky goes, look, I'm not a box of chocolate or a car to be liked or not liked. What matters is I serve my people and fulfill my duties. And then yesterday, President Zelensky gave this powerful speech and said, when I toured the Middle East, when I met with the leaders of Qatar and UAE and Saudi Arabia and Jordan and Kuwait, and they were asking for Ukrainians' help in building a security umbrella there that the United States cannot do, as they were asking for our drone interceptor technology, our drone surveillance technology, our affirmative drone offensive capabilities, our unmanned vessel capabilities and unmanned vessel interceptor technology. What was obvious to these Arab nations is that Ukraine is Europe, Europe is Ukraine, and Ukraine is a leader in providing security throughout for its allies. Watch what he said yesterday. Powerful speech indeed. Here, play this clip.
In the Middle East and the Gulf, when countries turn to Ukraine for support, they see Ukraine as Europe. They see it as working with Europe. No one there doubts that Ukraine is Europe. Ukraine's contribution to global stability is seen as Europe's contribution by everyone in the world. So why, in some key issues, is Ukraine still limited as a part of Europe? Ukraine's EU membership is a security guarantee for us and for Europe. Our potential human, technological, military is Europe's potential. Russia understands this, sometimes better than some in Europe. That is why Russia does everything to stop Ukraine from joining the EU, and that is why we are doing everything to make it happen.
But then Zelensky also reflected about how the U.S. keeps on saying, well, we're not really interested in talking about Russia's invasion of Ukraine anymore. We're too busy dealing with Iran. So, we're going to let up the sanctions on
He don't want
Russia and let
nobody
them sell
from
their
over
oil
there
and
to
make
tell on
billions of
him.
dollars a day. We're going to invite the Russian Duma leaders to the Capitol Hill, and we're going to then also release Russian sanctions or remove Russian sanctions on certain vessels. We're just too busy to deal with that. We're focused on Iran right now. What are you focused on doing there? Donald Trump doing press conferences where he just lies every day. Here, play this clip.
We have such risks, of course, because American side, it's not a secret, they're very open with this, that their focus is Iran, that Ukraine is not the first priority. They shared this message with my team, and my team said that, look, but anyway, we have such big, they said, yes, it's very important for us, the situation in Ukraine, the situation with the war, Russia against Ukraine, but you have to know this, our army is in Iran, and that's why Our focus is on Middle East. We hope that in the closest future the war will end, and we will come back to yours.
And then Zelensky, in this very revealing moment, says, I'll tell you what the United States has been repeating over and over again, that Donald Trump and Marco Rubio in the U.S., they keep on saying, withdraw from Donbass, get out of Donbass, and then we could try to make a deal. You just give up your territory, give up the Donbass region. And Zelensky's like, I'm not going to give up Donbass. Like, what are you talking about? Here, play this clip.
You have to withdraw, and we will give you security guarantees. And it doesn't matter what way. I heard it not once. So it's understandable for us, and it's understandable for us, and it's very understandable for American side. It's truth, but it's not about just American side. It's the ultimatum from Russia. For today, American side can't change the ultimatum of Russia. I think they can. I think that President Trump have enough power for this. He demonstrated it, not once. He has this to change Russian these narratives.
And it's notable because in the past 12 hours as well, Russia has repeated its public demand, Zelensky, Ukraine, withdraw from Donbass immediately. You have 2 months to withdraw or we are going to seize it by force. You've been trying to seize it by force. You want Donald Trump to extort Zelensky or to help hand over territory to you through coercion and other means, that which you can obtain on the battlefield through your invasion of Ukraine. And that's what Russia views as a peace deal. They want Donbass, then they're going to go into Kyiv. They're just going to keep taking. That is who they are. I mean, no doubt that is who they are. Going back to Zelensky here for a moment as well. During this speech also, he said, look, you know, we've always tried to have the backs of the people in Iran. And despite the fact that there's so much disinformation in the United States right now, we still believe that the American hearts have not grown so cold. And again, this is a clear reference to Donald Trump here. Play this clip.
We also see that many Iranians around the world respect Ukraine and are grateful that we did not stay silent about their pain and their desire to end dictatorship and live freely. And we all should act to help them, of course. And we feel that despite all the disinformation, American hearts have not grown cold. They support those who fight for freedom, and they support us in defending ourselves against Russian aggression. It's very important.
Hey everybody, Ben Meiselas here from the Midas Touch Network. I wanted to let you know about my podcast partner, Michael Popak's new law firm. It's called the Popak Firm. Michael Popak's pursuing his dream of starting his own law firm, really based on the popular demand by all the Midas Mighty and legal AFers who are approaching Michael Popak with their cases and saying, can you help us? And at that airspace.
Want to see the best deodorant in the world? This is Lumi, a deodorant that's one of a kind. Most deodorants just mask body odor with fragrance, which...
For strikes on Russian territory, you had the following Polish armed. If you have a case, it's 7 POPOK. An official account of the Polish armed forces also. An official account of the Polish armed forces also refuted Russia's disinformation campaign aimed at convincing audiences that Ukraine is using Polish airspace for strikes on Russian territory. You had the following Polish armed forces statement. In connection with false information appearing in the public domain, I firmly emphasize claims about the alleged provision of Polish airspace for offensive operations against the Russian Federation are completely false and have no basis in fact. Also, Russia's turning up its disinformation campaign and trying to help Viktor Orban, who is far behind in the election, which is set to take place in less than 2 weeks in Hungary, where we expect a pro-democracy coalition to beat Viktor Orban, but we also expect there to be a huge amount of tampering in that election by Putin and by Trump, who are trying to prop Orban up. As I mentioned, in the past 24 to 48 hours, the United States removing sanctions against Russian vessels. They already remove sanctions against Russian oil, but now they're removing sanctions against Russian vessels themselves as well. The United States has removed sanctions from 3 Russian vessels, according to an update from the U.S. Treasury's Office of Foreign Assets Control. The ships affected are the container vessels, and I'll list who they are. Ship tracking data shows that these vessels are currently throughout various locations. With sanctions lifted, the vessels can once again access ports, insurance, financial transactions, and international maritime services that had previously been restricted under U.S. sanctions. So, folks, as Russia is materially helping Iran, and they're saying it publicly, both the Iranian president, Pezeshkian, and Putin, they're saying it publicly, as they're helping to arm Iran, attack American military bases with precision, attack American soldiers. As that is taking place, Donald Trump keeps lifting sanctions and keeps on helping Putin over and over and over again.
Putin got that video.
Is doing, though, as Donald Trump is lifting
he got
sanctions,
pictures from
Epstein. This in a report that I did yesterday. Zelensky has been very successful in attacking all of the Russian bases of their oil exports, all of their oil export centers. Russia's seaborne oil exports collapsed in the wake of Ukraine's strikes on various Russian ports, with only 22 tankers for the whole of last week, down 45%. And as this Kyiv Independent story explains, hundreds of kilometers inside Russia, oil refineries burst into flames. Like 40% of the oil refineries in Russia have now been taken out, between 40 and 50% by Ukraine. And the sky above airfields and weapon factories are filled with thick black. In terms of Ukraine's ability to strike down these FPV drones, ballistic missiles, and Shahed drones, take a look at Ukraine's interception rate.
Yeah, I need for y'all to hit the like button if you want me to keep going.
2025, 79%, 84% in November, 81% in December. In 2026, in January,
double tap the face of your screen.
Interception rate, 87% interception rate in February, a 90% interception rate in March. No wonder all of these nations want to cut deals with Ukraine to help stop the Iranian ballistic missile Shahed drones and FPV drones as well. Finally, Zelensky posted the message about his conversations with the Chancellor of Germany, Friedrich Merz. During my conversation with the Chancellor of Germany, I informed him about my visit to countries in the Middle East and the protection systems we are offering to partners. I am grateful for the high assessment of our contribution to strengthening the protection of lives. Ukraine is ready for similar cooperation with European countries for the security of our continent. Friedrich updated me on his diplomatic contacts. We discussed in detail the negotiation process aimed at ending Russia's war against Ukraine, as well as our communication with the American side. Thank you for your principled position. Ukraine has never been and will never be an obstacle to peace. We are preparing contacts with partners in a broader format to coordinate positions and develop joint steps. Next month, we'll also see extensive bilateral work with Germany.
Jerry.
And then in this message that Zelensky made also in the past 12 hours, he said, look, we're ready for any ceasefire, an Easter ceasefire, a 30-day ceasefire, a 60-day ceasefire. We are not the barrier to ceasefires and peace. We're trying to have peace. Russia is the bad guy. It's pretty obvious, right? The problem is that Trump is the bad guy and has turned the U.S. into Putin bootlicker right now. And we all need to pay attention to what's taking place before our very eyes. The Russian Duma going to the Capitol last week, meeting with the State Department, the top Russian Duma leaders, basically like their senators. Donald Trump removing Russian oil sanctions, Donald Trump removing sanctions from Russian vessels, Donald Trump and Marco Rubio and his regime claiming that Russia isn't providing support to Iran and they don't know about it, while Iran targets American military bases. We have 13 military bases in the Middle East that have now been evacuated as a result of Iran being able to strike them with impunity, right? You had the big strike in Saudi Arabia and Riyadh. Who do you think's giving them this information? It's the Russians. We all know it's the Russians. Oh yeah, and by the way, Donald Trump letting the Russian ship bring the oil into Cuba, which, by the way, it's a war crime that Donald Trump was committing against Cuba. The embargo is a crime against humanity, regardless of your views of the Cuban regime. What Donald Trump was doing was a crime against humanity of the Cuban people, in my humble opinion. But Donald Trump was acting all tough. I did this embargo. Nobody can get through. Nobody can go to Cuba. And the Russian ship just went right into Cuba. And Donald Trump's like, of course you can come in. But Mexico, you can't. Colombia, you can't. Canada, you can't. None of our allies can. Just Russia can help Cuba. Why? To set up a base in Cuba right now? To more strongly cement Russian
They say he
influence over
stormed
Cuba
out
right
of
off the
court.
coast of
Hold
Florida? What are
on.
we doing here? What are we doing?
They say he stormed out.
Anyway, hit subscribe. Help me get to 7 million subscribers.
Okay. Thank you, Ben. Appreciate you. They say he stormed out, y'all.
Obsolete for those who have parents. We have some big news this afternoon. The Supreme Court just finished hearing oral arguments in a case that could decide whether or not Donald Trump will be able to change the 14th Amendment to the United States Constitution to make birthright citizenship obsolete for those who have parents who are undocumented. And while after hearing over 2 hours of oral argument, I can confidently say, both as a journalist and as a lawyer who has studied constitutional law in the past, that this Supreme Court is poised to rule against the President of the United States. And it's maybe why he left in the middle of oral argument after his Solicitor General was peppered with questions from the conservatives and the liberals on the court. I watched the entire oral argument so that you didn't have to, and I'm going to break down some of the key moments for you in this video. Before I do, make sure to like, comment, share, and subscribe. Subscribe to my Substack. Click the link below to support my work as I get you this in real time throughout the day, throughout the week. We're fighting to build something independent, and I'm bringing it to you not just from a journalistic perspective, but also from a legal one. So please subscribe if you can. I rely on you, so let's break it down. Today's Supreme Court arguments turned on a simple question: whether an individual born to 2 undocumented parents in the United States of America is automatically entitled to birthright citizenship under the United States Constitution. The 14th Amendment to the United States Constitution is clear in what it says regarding birthright citizenship. It says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States of America and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens in the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. That's the due process clause of the 14th Amendment. And while Trump is arguing that those born to 2 undocumented parents are not subject to the jurisdiction thereof of the United States, but the first clause, born or naturalized in the United States, well, that is what this question turns on. If you are born, are you a
President
citizen?
never
And
attended
his answer to
Supreme
that
Court
is
in
seemingly
history.
yes.
Never.
It looks as though the justices will agree.
He has a personal reason why he wants this to go forward.
A conservative on the bench, who contradicted what Trump's attorneys
He
were
has
trying to
broke
argue.
the law and he needs to go to prison immediately.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out to, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. You said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our...
It's a new world, but it's not a new constitution. And I think that's a critical point that a lot of folks are making. Well, if you look at the text of the Constitution, the text of the Constitution is clear. But what John Sauer and the Trump administration are arguing isn't that clear.
Egomaniac.
Justice
Absolutely.
Coney Barrett, another conservative, kind of laid this out pretty clearly for him. Take a listen.
act that creates allegiance. That's
General,
General,
so
you
can I?
said
Try
in your
to
reply
intimidate the
brief
judge,
that
stare them
the
down.
children of slaves who were brought here unlawfully,
Tell him,
you
you
know,
better vote.
in defiance of laws forbidding the slave trade, would in fact be citizens. And you can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they
What
would
about
be
all
citizens.
those people that they
But
traffic?
that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite.
But it's not just Justice Coney Barrett and Justice Roberts who are a little concerned about this oral argument. It's also Justice Gorsuch. And there was a moment during today's argument where Justice Gorsuch plainly asked Trump's lawyers, hey, under your legal theory, would Native Americans be considered U.S. citizens? Take a listen to what he had to say.
Native Americans today are birthright citizens under your test and under your friend's test.
I think so. I mean, obviously they've been granted citizenship by statute.
Put aside the statute. Do you think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright citizens.
I understand that's what they said, but your test is the domicile of the parents, and that would be the test you'd have us apply today, right?
Yes, yes. So if a tribal Indian, for example, gives up allegiance to...
Born today, birthright citizens.
I think so, on our test. Yeah, if they're lawfully domiciled here.
Okay, and then
not sure, I have to think that through, but that's my reaction.
I'll take the yes. That's all right.
I have to think that through. It's not a clear-cut yes. And, well, it wasn't just the conservatives who were concerned. It was also the liberal justices. Here's what Justice Kagan had to say.
It's the principle. That principle clearly applies here. I also respectfully disagree.
Yeah, and I guess, Mr. General Sauer, where does this principle come from? Allegiance, domicile, allegiance, I think you point to a Lincoln funeral speech as your primary example of where this principle comes from. It's certainly not what we think of.
They don't already line themselves with,
and I appreciate that jurisdiction has many meanings. But the first meaning
they get
is
tax breaks.
If you're subject to jurisdiction, you're
they
subject to the
cheating on
authority
their taxes, so they gonna make it balance out.
What that means is a certain kind of allegiance that domiciliaries have and nobody else does. So the text of the clause, I think, does not support you. I think you're sort of looking for some more technical, esoteric meaning. And then the question comes, okay, if the text doesn't support you, if there's a real history of people using it that way, but as far as I can tell, at the time of the 14th, you're using some pretty obscure sources to get to this concept.
Well, take it straight from the framers' mouths.
She's right. And I think the final moment that I think you need to see is from Justice Jackson today. So take a listen.
You will still get a...
You're not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressing that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you.
So that's where we're at right now. As always, make sure to like, comment, share, and subscribe. Subscribe to my Substack. Click the link below if I have to predict.
Hold on. Talked about him storming out. Mad. What you mad for? You tried to stir. He would make eye contact with you. He would make eye contact with you. All three of them wouldn't. This on my fur.
Poked holes in Trump's. Today, Donald Trump made two very different kinds of history. The first was him being the first sitting president to watch oral argument take place before the Supreme Court. The second was being the first sitting president to watch his case fall apart in oral argument before the Supreme Court. And that is exactly what just took place today, and why Donald Trump, furious as ever, is storming out of the Supreme Court, because his attempts to overturn birthright citizenship have blown up in his face, and it is another in a long line of legal losses for Donald Trump. And it is no surprise. This case makes no sense and is a last-ditch effort by Trump to, I guess, throw a little racist red meat to the base, but also stop anyone he possibly can from voting in the midterms, considering how the polls are looking right now. And it is why Donald Trump had this rambling mess to say yesterday about how he predicted this case would go.
The Supreme Court tomorrow is going to hear arguments about your executive order trying to get rid of birthright citizenship.
And I'm going.
You're going to go to the Supreme Court
I think
tomorrow.
so. I do believe
And sit there and listen.
because I have listened
Say
to
no
this
to
argument for
anchor
so long,
babies. I don't
and
know
this
what
is not
anchor babies
about
are.
Chinese billionaires or
yeah, so,
billionaires from other countries.
say it a better way. I don't know what you're talking about.
Or 59 children in one case.
Speak
or
straight.
10
Don't hide
children
behind clever
becoming
little
American
ways of getting your
citizens.
point across.
This was about
Come straight
slaves.
with it.
And if you take a look,
I don't know what you're talking about.
We're talking about slaves from the Civil War. And if you take a look at when it was filed, all of this legislation,
But watch your
all of
mouth.
this, everything
You
had
better
to do
check
with
the
birthright
room.
citizenship.
And
It
yes,
was at
I
the end
said
of the Civil
better.
War. The reason was it had to do with
Random.
the babies of slaves and the protection of the
You better
babies
watch
of
your
slaves.
mouth, yo.
It
You're
didn't
typing.
have to do
Because
with
I'm
the
going to put your
protection
monkey
of
ass out.
multi-millionaires and billionaires wanting to have their children get an American citizenship. It is the craziest thing I've ever seen. It's been so badly handled by legal people over the years. If you look...
Ah, yes, the great legal mind of our generation, Donald Trump, saying, well, quite frankly, it's not about 900 kids or 90 kids or China. It's about, well, we don't know what it's about. Donald Trump once said that the Declaration of Independence was signed after the Civil War. This is not a genius historian who is connecting all the dots and making some case that outlines a misinterpretation of the framework of the Constitution. Donald Trump is just angry, he's bitter, and he's trying to undermine our democracy in whatever way possible. And the fact that we are even seeing this oral argument is a stain on the Supreme Court, and Donald Trump has given us lots of those, but it's not going too well. It's why Trump stormed out. We're going to get to that in a second, but I want to start with an update on how the case is actually going. Humiliated Trump watches own justices tear his citizenship case apart. Conservative justices poked holes in Trump's argument as the president looked on. Even some of the conservative justices on the Supreme Court expressed deep skepticism in the Trump administration's argument for upending birthright citizenship, as the justices took turns launching a series of brutal questions at the Solicitor General after he made the government's argument on Wednesday. Donald Trump was sitting in the courtroom watching. Chief Justice John Roberts, along with Justices Neil Gorsuch and Amy Coney Barrett, asked probing questions that suggested they were not buying the argument to dramatically restrict birthright citizenship. Roberts used quirky, while Barrett said she was puzzled. At the root of the case is the 14th Amendment, which states all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. But the Trump administration argued that the Citizenship Clause of the 14th Amendment was meant to grant citizenship to freed slaves and their children after the Civil War. The ACLU, which was arguing the case on behalf of the children born in the U.S., slammed the Trump administration for trying to overturn a century of Supreme Court precedent and U.S. Constitution. As we see Donald Trump's lawyer saying, we're in a new world where 8 billion people are one plane ride away from having a child who's a U.S. citizen. John Roberts, not buying it, said, it's a new world. It's the same Constitution. Yes, Donald Trump should not be able to upend the legal framework on which our country rests because of planes and air travel. That seems a little bit sketchy and maybe not the most sound legal argument, but this is what Trump's lawyers do. They go in, they sling some bullshit, they hope that they can get a favorable judge or favorable justices, and unfortunately in the past they have, but it at least seems like from the skepticism that's been has kind of been projected out, what we've heard in these initial oral arguments, that Donald Trump, he does not have a winning case, and it is why he got fed up, probably fell asleep a little bit, and stormed out of the Supreme Court, leaving furious, of course.
United States Supreme Court hearing arguments for and against what's called birthright citizenship. By the way, we're told the President of the United States, President Trump, has just left the Supreme Court, heading back in his motorcade to the White House. He was there when John Sauer, the Solicitor General, was making his case against birthright citizenship. But now Cecilia Wang, the legal director of the American Civil Liberties Union, the ACLU, is making the opposite case against the Trump administration. Trump has gone back to the White House, isn't hearing this part, at least not in person. We're going to continue.
So Donald Trump left. He didn't want to stick around. He didn't want to hear any more. And to me, that is probably not a good sign for Donald Trump, but it is a great sign for birthright citizenship. It is also, we must reflect upon the fact that we are only in this position, and these, conservative justices are only responding the way they are, case of Amy Coney Barrett, puzzled, John Roberts, confused, concerned, not appreciating the argument that's being made, because they allowed this. They allowed Donald Trump to return to power. Right? They are just as complicit as anyone, as Mitch McConnell, as Kevin McCarthy, as anyone who is unwilling to stand up to Donald Trump. They are complicit. And so if you do not like, as John Roberts has said, the partisanship that people view the Supreme Court with, the way that our government has increased dramatically the amount of political violence that exists in our country, then John, you should do a little looking in the mirror, because it is because of this Supreme Court. Now, Donald Trump, certainly not happy if he's not sticking around for everything. I'm sure a Truth Social post is coming. I'm sure there will be some sort of meltdown at some point. So do subscribe and stick around for that. Hit that notification.
Okay, y'all, I'll be back later on.
Again, this is just part of Donald Trump's larger last-ditch effort to try to preserve any political power by attacking the very basis of our elections. And it comes as Donald Trump yesterday signed another executive order that will likely be quickly struck down, essentially upending the ability for most people to vote by mail, which Donald Trump did. And Lawrence O'Donnell and Senator Sheldon Whitehouse called it out, and
history
I think a perfect
of the election,
takedown right here.
Is a
We'll
lot
start
of
with
problems.
the fact that this guy's polling is in the 30s. He's stuck us in a totally unpopular war. Corruption is everywhere in plain view, and people's cost of living is getting worse every day. So he's looking at that mess that he has made, and he's figuring out, how do we get out of that? We got to throw the election. And he's tried it with the SAVE Act, and in the House and in the Senate, his Republican members of Congress, with their usual spines of foam, have gone along with that effort. And of course, they grabbed the Georgia election records, and we're going to find out what that's all about. But with this, with an executive order, he has now made himself subject to a lawsuit. And the segue to your last segment is that there's going to be litigation about this. He lost, for instance, his offshore wind executive order in a case up in Massachusetts. And now he's going to have to go into court this time, not with spines of foam Republican members of Congress, but into court and try to defend this. And there's some data points that are pretty interesting. Mike Lee of Utah has been the lead voice for Republicans on the SAVE Act. In Utah, the Republican lieutenant governor reviewed 2 million ballots and found that one person out of 2 million had registered without proving that he was a citizen, but he hadn't voted, so 0 voters. And when a similar law passed in Kansas some years ago, they looked at the facts there and they found that 67 people over nearly 20 years had attempted to register without proof of citizenship. 67 people in 20 years. And the law going after those 67 people who may never have voted, they just attempted to register, was to disenfranchise 31,000 legitimate voting Kansans. So when they get into court and they have to answer to facts like that, it's a very different environment than if you're just asking your spines of foam Republicans in Congress to go to the floor and say what they're told. So, you know, I think they stepped in it with this one, and I'm really looking forward to that litigation.
What is happening right now is disgraceful. Donald Trump knows that this is illegal. He knows his attack on mail-in voting is illegal. He knows his attack on birthright citizenship is illegal. More than anything, they are just trying to create a public narrative. And honestly, I think it's something that Democrats should learn from. Campaign-wise, get caught trying. When you're governing, get caught trying. Do these things, right? Like, not try to overturn birthright citizenship, but in some effect, go out and try to make big structural change, no matter what it will run into. At least shift the dialogue. Donald Trump has spent his entire political career trying to shift and normalize the rhetoric that he uses, and he has been successful. How did we get to a place when he has been so normalized, where the outrage only comes when something truly unprecedented happened, but something unprecedented happens every single day? Donald Trump has got us, and by us I mean the mainstream press that doesn't do its job, so accustomed to his outrageous behavior that he's able to fall asleep in cabinet meetings and nobody bats an eye. He's able to say that he wants to overturn 100+ years of precedent and nobody bats an eye. They say, well, Donald Trump is trying to make a legal argument before the Supreme Court. This is an attack on the very basis of our country, and that is the only way that it can be covered. And if it's not, it's a failure of whoever is doing so. But Democrats, learn a lesson from this. Try to change the dialogue. Be big and be bold and say that government work. Be like Zoran Mamdani. Okay, and Zoran's having success with everything that he's doing, but he was told on the campaign trail that he would run up against the buzzsaw of corporate Democrats in Albany and Kathy Hochul, and he is moving them right now through public pressure, through organizing, rallies with Bernie Sanders and other progressives and Democratic socialists. We need to take a lesson, not in upending the Constitution, but in how we communicate these things and fundamentally change how people at least view issues before we fundamentally change the issues themselves. That is necessary. That is necessary for Democrats to succeed, and that is necessary to maintain our country and actually change the material conditions of working people. And that is what we're going to talk about every single day on this show. And if you want to support that, as always, you can hit that subscribe
y'all, I'll
button,
be
leave a
back
like on this
later.
video. If you stuck around to the end, drop a blue heart in the comments. If you want to support the show another way,